We'll continue with the questions from the panel.
Okay. Are there questions from behind?
Oh, no, Jess.
First thing I want to do, Frank, is I want to acknowledge that I've got a lot of feathers in my mouth over the years. When IGRA was first passed, I was throwing big rocks at you. And I have to acknowledge I need to eat all of those feathers, all of those rocks I threw, and I want to thank you. There are times in Indian country when people stand up and do what they think's right, and time passes and people understand that what you did is really beneficial, and I want to thank you for the beneficial acts you did back in 1988 and prior years for us. I've got one question that I want to ask you. I'm a member of the International Masters of Gaming Law, and all over the world, it seems the world understands that when you talk about Class 2, even though it doesn't have any legal implication there, in Mexico and in other places, they understand you're talking about player participation, server-based bingo. Did you have any idea that this would be this big all over the world?
First, Jess, let me say that you know, IGRA was the result of some major compromise. We were faced, as I mentioned at the outset of my discussion this afternoon, with some very powerful forces, as you know, and George knows. Our major opponent in the House was Tony Coelho. Tony, congressman from California, was the majority whip, you know, the third most powerful Democrat in the House. We had Chairman Pepper from Florida, who was the chairman of the Rules Committee, the most powerful committee in the House. And all across the country, as George and you and others know, governors and AGs and industry and the charities and the churches, and we're all adamant that Indian gaming come to a halt and be subject fully to state control and regulation. I'm digressing here, but I just want to put it on the record. George mentioned Cabazon and how it influenced legislation. The Indian bar, I'm sure George included, were very afraid of the Supreme Court taking an Indian gaming case. In the Verona and Seminole case, they decided not to hear an appeal, but there was general fear in the Indian bar that the Supreme Court was going to take an appeal at some point, and based upon their record, that court's record, including the Rice versus Rayner case in Arizona that Sandra Day handed down on state licensing of Indian liquor sales, that they were most certainly going to overturn those good cases. So when they finally did take Cabazon in June of 1987, 86, 87, somewhere there.
They decided.
They took it in 86, they decided in 87.
Yeah, 86. When they took that, agreed to hear Cabazon, it just changed the legislative dynamics for us. And in this paper I provided, I drafted a bill for Mo that was one of the worst bills I ever drafted and would have stripped tribes of sovereignty. But we were sure that we were going to lose in the Supreme Court, and I was trying to salvage whatever we could. So Mo introduced that bill in January of 1987. And the Coelhos of the Congress rejected it. I didn't know where we were going then. Then in February of 87, the court handed down Cabazon. We jerked that worthless bill off the table and we redrafted another one, which is basically what IGRA is now. But it's a result of compromises. It invades tribal sovereignty. I just wanted to put that out there. I had never I never thought about Indian gaming standards becoming international issues. Never did.
That's all.
Like John McCain, I didn't realize they'd get so big.
I have one question for Frank, and it goes to what you talked about earlier about the power of the NIGC and the history of IGRA in the 98th, 99th, and 100th Congress. And in the 98th Congress, the original version of the bill that first spoke of a National Indian Gaming Commission, could you kind of speak to how and elaborate on how the first rendition of that were regional commissions controlled by tribes, and then how it kind of devolved into what it is now?
When we first, in the 98th Congress, when I drafted that first bill, there was no thought of there ever being a commission. It was going to be the Secretary of the Interior. Whatever federal involvement there was to be in Indian gaming, it was going to be through the Secretary of the Interior. As the legislation evolved, it became clear that the Secretary didn't want that responsibility. And Senator DeConcini of Arizona, in a bill that he introduced in the 99th Congress, came up first with the idea of some commissions, regulatory commissions on Indian gaming, and they were to be regional regulatory commissions, largely controlled by the tribes of that region themselves. It really went nowhere. The other side were not going to accept that kind of thing. My boss, Mo Udall, his committee had at one time had jurisdiction over the Atomic Energy Commission, Atomic Energy Act, and which included Atomic Energy Commission, which was a multi-member commission, and Mo was very unhappy with the way that commission carried out the responsibility. And he said to me, you know, what we need a czar like the baseball commissioner. One person who just is the czar, and it scared the hell out of me when he said that. And we finally got him off of it. And at one point, the commission, we got him to agree that a multi-member commission was better. And at one point, it was 5, and later 3. It again was a compromise, and unfortunately turned out not to be all that good.
Thank you. And Dean Rand, I have a question for you. To what extent and how do you think tribal regulators could embody in their written tribal regulations language in the history of IGRA concerning the difference between aids and facsimiles and the term maximum flexibility?
I think I'll give you 3 answers to that question. The first answer is that I think that the statutory language as well as the legislative history gives tribal gaming commissions very strong arguments about the extent to which they're able to operate Class 2 machines, that maximum flexibility is, as Frank indicated, meant to be the most flexibility. So that's a legal answer. My second answer for you is a political one, and that's that those legal arguments don't exist in a vacuum. The political environment does have an effect on the decisions and the consequences of the decisions that even a tribal government makes. So that I think that in making those decisions, the Tribal Gaming Commission should at least be cognizant of the political atmosphere and the political environment in which those decisions are made. And then my third answer has to do with tribal sovereignty and tribal self-determination. Those decisions, again, come from the inherent authority of the tribe, not from authority that's been delegated to the tribe through IGRA or anything else. These are the decisions of the tribe in exercising their tribal sovereignty. And I think that within the confines of the regulatory structure of IGRA, tribal gaming commissions should make decisions about what best serves their tribe, their tribal members, their tribal governments, their tribal institutions, and make those decisions accordingly. Now, I gave you 3 different answers because each of those might not bring you to the same place. And all 3 of them, I think, are probably at least relevant, but they might not all 3 be as weighty, depending on a particular circumstance. And I think that those are decisions that simply belong to the Tribal Gaming Commission.
Thank you.
Mr. Ducheneau, I have a question for you about the language on games similar to bingo in the statute. Even though the category of games similar to bingo is listed separately from bingo, the NIGC previously defined games similar to bingo as a game that had to meet all of the statutory requirements of bingo. They changed that definition in 2002 to describe it as a variant, but as a practical matter, staff at the NIGC still take the position that unless a game meets all of those requirements, it can't even be a game similar to bingo. From your experience drafting the language and being involved in those discussions, do you think that Congress intended that games similar to bingo include games that do not necessarily meet all of the requirements for bingo?
There's George probably knows this a lot better than I do. There's another rule of construction that courts use in interpreting acts of Congress, and it has something to do with, you know, that the court is not going to render some part of an act meaningless unless clearly it is meaningless, you know. So what the commission is attempting to do is to render the phrase "and games like bingo" or whatever it is meaningless, and by saying that games like bingo have to have the same characteristics as bingo, and that's an absurdity. It's oxymoron to say that they're the same. Why would we have included that phrase in the act if all we meant was those games had to be the same as bingo? But you don't do an unnecessary thing or something. I don't remember what the rule of construction is, but that's a silliness on the part of the commission to say that a game like bingo has to be bingo. You know, it's silly.
Okay, I think we have, Michael, you have another question? And in the interim, I've come up with a couple more, but I'll let Michael go first.
I'll try to, my comments, I hope I'll try to make them very brief, but to Professor Rand, if the intent of Congress was the tribes would be the primary regulators of day-to-day gaming through their gaming commissions, and each tribe is an independent sovereign entity unto itself, part of the conundrum for us is establishing uniform practices and procedures and still respecting the individuality of each tribe. To that end, the California State Compact, and there are many reiterations of it today, I've lost count of how many different compacts there are in California, do all share in common the requirement that tribes have minimum internal controls and policies and procedures. To that end, when the National Indian Gaming Commission adopted the minimum internal control standards that Mr. Ducheneau talked about, the Federal Register contained a recommendation that the manner in which a tribe could become in compliance with that standard would be to amend their tribal gaming ordinance and add that. And indeed, I think, and George can correct me if I'm wrong on my facts, virtually every compacted tribe in the state of California, in fact, did that. They amended their tribal gaming ordinances to incorporate those minimum internal control standards, sent them to the National Indian Gaming Commission, and used those to develop the policies and procedures that became the basis for our independent certified public accounting agencies to conduct our financial statement audits and our minimum internal control standard audits. With the CRIT decision, one of the two state gaming agencies took the position that a void now existed because the National Indian Gaming Commission could no longer provide oversight regulatory authority in that area. So the state of California 18 months ago proposed a regulation that would impose a uniform minimum internal control standard adopted by the state, modeled after the NIGC, and enforced on the tribes. Does that seem to be consistent with the intent of Congress? And it has precipitated a rather strong disagreement between both state gaming agencies, one that voted for the regulation, one that voted against it. And in perhaps something we'll never again see in our lifetimes, every single tribe, 56 tribes in the State Gaming Association, voted against that regulation. Do the tribes have a basis for objecting to the state attempting to impose a minimum internal control standard by adopting a regulation? What's your opinion on that circumstance?
As Frank indicated earlier, Class 3 gaming, under Congress's intent in the CRIT decision, is regulated according to a duly negotiated tribal-state compact. That's not to say state law, although the compact could, through the agreement of both parties, incorporate aspects of state law. It seems to me, in the situation that you've described, that the only appropriate way for the state to do that is to negotiate with the tribes to amend the compacts to allow that regulation. And it would seem to me, too, that the tribe's stance would be that it would be unnecessary because the tribes have already adopted the mix through their own law, so there would be no reason for a state regulation. But certainly, under IGRA and the intent of Congress, a tribal state compact is meant to be a duly negotiated agreement between two sovereigns, not one in which the state takes advantage of the situation to simply impose its will on the tribe.
Okay, I just have one question that I've been wanting to ask, especially Frank in particular. For the last, certainly the last 7 years and maybe longer than that, the NIGC has taken the view that in the wording it says it's an independent agency within DOI, and they've stopped that independent agency and really sort of thumbed their nose at any regulation or a requirement of federal agencies that they didn't like or couldn't comply with or otherwise weren't aware of. I'm assuming that isn't what was intended, and I'd like to have your view on that.
When we developed the concept of the commission, as I said earlier, it was done with the understanding that the Secretary of the Interior did not want the responsibility for day-to-day regulation, that they didn't have that capability. So based upon, and Justice said they weren't interested. So based upon that, the commission concept was developed for carry out the responsibilities that are in IGRA. Where to put it, where to place it administratively. The decision was made, and I don't remember by whom and at what point in the proceedings, that as an Indian-related entity, which also, if you read IGRA, has some trust obligations, that it ought to be in that department, which had general responsibility for Indian tribes and the trust responsibility. So it was located in the Interior Department and has some, I don't know why they want to call it reporting, but there's a definite, it's under the Secretary in one sense. But if as a regulatory agency, it had to have some degree of independence. And I think that was the terminology used, an independent agency within the Department of Interior. And I don't think that Phil can go off and say, we're totally independent of Interior.
Yes, well, he's recently said that he was appointed by the President, confirmed by the Senate, does not serve at the pleasure of the President, but although he will try to act as a member of the administration if it's convenient. And I was wondering if, that's sort of the basis of that question, is that independent agency doesn't mean that you're a federal judge, for example.
No, and it's like Cheney, I was not a member of the executive branch. Ridiculous.
Well, that's sort of what it sounded like. And I have one I guess, sort of conclusionary thing. Based on both of your testimonies, I sort of would characterize it in my mind. I've been thinking about it as, I would call it the dirt ball argument, and there are those that would like to see the tribe swing at a ball in the dirt, or a baseball argument. You know, they're going to throw you curveballs, they're going to throw you lots of things to see if they can get you to lean their way, to play the game they want you to play the game. For example, by using terminology like bright line, or distinct line, or no independent oversight. And I guess it's my sense from both of your testimonies, and you can tell me if my conclusion's right, is that that's exactly what those, and some in the federal government, some in the state government, some elsewhere, are trying to get the tribes as a group to swing at the ball in the dirt, and that we shouldn't do that.
I'm not sure what you mean by swinging the ball in the dirt. I guess.
Okay, well, you know, we're all in the game together by the statutory framework that was presented and passed by Congress and IGRA. The states have their limited role when it comes to compacted games. The federal government has oversight, but the tribes are the primary regulators and have primary responsibility over their games.
I agree.
But because terminology like bright line, no independent oversight, those sort of politically provocative statements are often used by both the state and some in the federal government. They're trying to throw us off the game. They're trying to make us think that they have more authority or more right to have authority than the tribe does.
Right. Okay, I see what you mean. Again, if you look at the language of IGRA and the legislative history, our intent, at least mine, was that the commission was to assist tribes in achieving the primary goals of IGRA: strong tribal governments, economic development, and I don't remember the other one. That the commission, in carrying out its regulatory responsibility that it clearly did have, not the ones that it's reached for, was intended to assist tribes in achieving those goals and not to frustrate it. And bright lines, I don't see in IGRA the term bright line. No, I just don't see it. We wrote an act, it's imperfect, it's ambiguous. If it's ambiguous, it ought to be construed in favor of the tribes. You know, they're just, I don't know what you call it, dirt balls, but I don't know why they're doing it, why the commission and Hogan and others are talking about bright line. I thought the courts had established a fairly bright line with respect to Class 2 machines. I don't know why we need anything more from Phil.
Well, this is a first because you've inspired me to attempt my own baseball analogy, so I want you to know that I'm way outside of my comfort zone. I think that it's possible that the tribes are being thrown foul balls, and it may fall on the tribes to call the foul instead of taking the swing. Is that close to real baseball?
Well, it's close enough, I think. It's close enough. Thank you. I have no other questions, Madam Chairman.
Are there any other questions? I'd like to thank you, Mr. Ducheneau and Dean Rand, for this very informative panel discussion.
Thank you very much.
Thank you.
This concludes our testimony for today. I would like to acknowledge the participation of the California Gambling Control Commission by the attendance of Jason Pope and William Ping. The hearing will recess until 10 a.m. on Thursday, May 7th, 2009. Thank you all for coming. We look forward to seeing you tomorrow.